Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and I am back with another video on the same topic, that is the Indian Evidence Act. We have already done one lecture on the Indian Evidence Act and today it is our second lecture. So I have been stressing on this point that their security laws, they form the most important part of your syllabus. But in the preparation of your syllabus, in the preparation for your examination, please don't leave the other topics. They also are important for your examination, right? So you have to be very careful about the criminal law also, that is the Evidence Act, the Indian Penal Code and the CRPC. So please make sure that you are going through these topics as well, because they also are important for your examination. You cannot leave these, right? The security laws, they are the most important part. No doubt the security laws, they are the most important part of your syllabus, but at the same time you have to go through rest of the syllabus as well, that is the criminal laws and the company laws. Before I start, I would like to tell you that EduTap has come up with two courses, the first one being the test series and other one being the live crash course. The test series for the phase 2 examination includes chapter wise test, which means you get test for each of the chapter that has been mentioned in your act, which has been mentioned in your syllabus. So for each chapter, for example in IPC, in CRPC, you get separate test which you can practice. The second feature includes full-length tests with evaluation. So as descriptive part has been introduced for the first time, it will be very helpful for you. Our experts are going to evaluate your answers and give you necessary feedback, which is going to be very helpful for your preparation. So please make sure that you avail it, right? And also you get one-on-one mentor support. At the same time, we also have a live crash course and the live classes, they are already going on, and the classes which have already been conducted, you get the recorded sessions of that. So that means even today you can buy this course and you can start your preparation. It is going to be very helpful for you. Plus you get short notes for your descriptive part. It will be very helpful. You can take the help of these short notes and prepare your descriptive portion, right? And all the features of the test series, they are also included in the live crash course. So for your revision, it is going to be very helpful, and you also get one-on-one mentor support. So we are running a limited time period offer. If you want to avail it, you can refer to the link in the description below. Now let's start with our lecture. Question number 1. Under the Evidence Act, fact means fact probandum, factum probamus, both factum probandum and factum probandum, none of the above. So the answer to this question is option C, that is both factum probandum and factum probans. So evidence, they include both factum probandum. Factum probandum is something that is to be proved in the court, right? So the fact that you want to prove in the court, that is factum probandum, and through the facts which you will use to prove this main fact, the main fact in issue, those evidentiary facts, they are called what? They are called factum probans. So factum probans, they are actually the facts that you use to prove the main issue, that is factum probandum. So you use factum probans to prove the factum probandum. So factum probandum refers to the ultimate fact which has to be proved or proposition to be established, that which a party wants to prove in the court, and factum probans refers to the evidentiary fact by which the factum probandum will be proved. Question number 2. Which of the following persons are considered as experts as per section 45 of the Indian Evidence Act? So the answer is option A, that is all of these persons skilled in science or art, persons skilled in identifying handwriting, persons skilled in identifying finger impressions, persons skilled in foreign law. Opinion of experts. So as a general rule, the opinion evidence, they are not admissible in Indian Evidence Act, but here it is an exception. It is the opinion of someone who is specially skilled. Here the term used is specially skilled. What is specially skilled? Specially means that that person has special knowledge in that area. He has special knowledge in that subject matter, and he is skilled. Skilled means he has requisite knowledge and requisite experience in that area. So he is what? He is specially skilled, and that is why the opinion of that person, the opinion of that expert is made relevant here. But you must know that opinion evidence, it does not have a very high probative value, right? So when the court has to form an opinion upon the point of foreign law, or science or art, or as to identify the handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, science or art, or in question as to identify handwriting, finger impressions are relevant facts, and such persons, they are termed as what? They are called the experts, right? So this section, it comes into play when you have to form an opinion regarding any of these, that is it can be for foreign law, it can be for science, art, any opinion it has to be made on these subjects. Why is it made like that? Because a court, it cannot be expert in every matter. So we have to take the opinion of another person in establishing that certain fact. But I have already told you, you must remember this, that opinion evidence, it does not have a very high probative value, right? Question number 3. According to Section 61 of the Indian Evidence Act 1872, the answer is option D. The contents of the document must be proved either by primary or secondary evidence. So this is Section 61. The contents of the documents may be proved either by primary or by secondary evidence. Question number 4. A intentionally and falsely intends B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. Applying Section 115 Indian Evidence Act, the answer is option D. He must not be allowed to prove his want of title. So this is given in Section 115. So let's read this section. When one person has by his declaration, act or omission. So he has either made an act, he has made an omission, or he has declared something intentionally, caused or permitted another person to believe a thing to be true, and he has intentionally done what? He has intentionally caused or permitted another person to believe a thing to be true, and he has intentionally done what? He has intentionally caused himself, he has caused, or he has permitted another person to make that declaration, and a third person, he is believing it to be true, right? Person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. So basically, for example, someone has made a representation, and on acting on that representation, another person, he acts, right? He does an act in consequence of that representation. Now the person who made that representation, it might not be true. So that person who made the representation, he cannot be allowed to take back that representation. So let's understand the question, what is happening here. For example, there was a case, there was a property case which was going on between A and B, and A had a property, it was for, let's say, 10 crore rupees. It has been 25 years and A has given up all hopes. He thinks that this property is never going to come to him. So now what happens? X, he comes to A and he asks that, is this your property? I want to buy it. Now A intentionally tells X that yes, this is my property, because he knows that he is not going to get that property. That is why he intentionally says yes to X, that this is my property, and X says that I want to buy it. I will buy it for example, for 5 crore rupees. Now A, he knows that this property, it does not belong to him right now, but he does what? He actually sells that property to X for 5 crore rupees, because he knows that he is not going to get that property. That is why he makes that sale, that nevertheless I am not going to anyhow get 10 crore rupees. So what will I do? I can get what? I can get 5 crore rupees. So now what happens? A actually wins the case. The verdict, it comes in favor of A. Now A, he cannot be permitted to say that that property, when he made that sale to A, that property did not belong to him. Now he is barred from doing so. Now he is stopped from doing so. This is what? This is estoppel. Now he cannot say that when I made that sale, I did not have the title. So this is what the question says. This is the illustration. Let's read this. So A intentionally and falsely leads B to believe that certain land belongs to A. So he made him believe that yes, this is my property, and thereby induces B to buy and pay for it. The land afterwards becomes the property of A. And now what happens? He actually wins that case, and A seeks to set aside the sale on the ground that at the time of the sale he had no title, but he is stopped now because of this section. He cannot do so. He must not be allowed to prove his want of title. So he cannot now prove that at the time when the sale was made, the title, it did not belong to me. I had no title in that property. He cannot do so. He is stopped under this section. Question number 5. Dying declaration can be sole basis of conviction if it inspires full confidence of the court. The court should be satisfied. The answer is D, the A and B. The deceased was in a fit state of mind at the time of making the statement, and that it was not the result of tutoring, prompting or product of imagination, right? So we have done what is dying declaration in the last lecture. The court must be further satisfied that the deceased was in a fit state of mind and had in fact a clear opportunity to observe and identify the assailants. Once the court is satisfied that the declaration was true and voluntarily, undoubtedly, it can base its conviction without any further corroboration. It cannot be laid down as an absolute rule of law that dying declaration cannot form a sole basis of conviction unless it is corroborated. The rule requiring corroboration is merely a rule of prudence. Alright, question number 6. Examination in chief of a witness. The answer is shall be by the party calling the witness. So someone who calls a witness, they are going to do what? They are going to do examination in chief. Then the adverse party will cross-examine that witness, and then in case there is a need of re-examination, then the party who actually called the witness is going to re-examine them again, right? Examination in chief. The examination of a witness by the party who calls him shall be called examination in chief. Cross-examination. The examination of a witness by the adverse party shall be called cross-examination, and re-examination, the examination of a witness subsequent to the cross-examination, this is after cross-examination, by the party who calls him shall be called re-examination. Question number 7. Leading questions can be asked during. The answer is B, that is they can only be asked during the cross-examination. First of all, you have to understand that what are leading questions. Leading questions are the questions which actually have the answers hidden in them. For example, if I ask that is it not true that your name is A, or is it not true that you live in Delhi, these are what? These are leading questions which have the answers to them also in the question, and you, the person who is making those questions, he expects that these answers, the answers that are already hidden in the question, they should be answered in the same manner. That is why they are doing what? They are asking you a leading question. But according to the Indian Evidence Act, a leading question, it cannot be asked in the court by the person who is actually bringing that person. But according to law, the leading questions, they cannot be asked in the examination in chief and re-examination. So the person who is bringing the witness, for his own interest, in his favor, they are not allowed to ask them the leading questions, but a leading question can be asked in a cross-examination by the adverse party. Why? Because the main purpose of a cross-examination is to breach the credibility of the witness, right? So that is why a leading question, it can be asked in a cross-examination by an adverse party. But some leading questions, they have been made permissible by the court. For example, the introductory facts, the questions with the introductory facts, the ones I gave you the example. For example, is it not true that your name is A? That is his introduction. If he says yes, my name is A, in that case there is going to be no problem. Or it can be of an undisputed fact, a fact which has already been proven in the court, which is undisputed. You can ask leading questions for that facts also, right? Cross-examination is generally limited to the questioning only on the matters that were raised during the direct examination. Leading questions may be asked during cross-examination, since the purpose of cross-examination is to test the credibility of the statement made during the direct examination. So leading questions, they can be asked in the cross-examination, but they cannot be asked by the same party who brings that witness in the examination in chief or re-examination. Alright, question number 8. A party person who calls the witness can be permitted to cross-examine the witness so called by him as provided. The answer is section 154, option number C. So section 154 actually deals with the hostile witness. The word hostile witness has not been mentioned in this section, but this relates to hostile witness. So what is a hostile witness? Someone who goes against the party who brought in. So you were brought in, for example, by A to speak something, to give an evidence in favor of A. But in the course of that case you actually gave statements which were against the interest of A. In that case, you have turned into what? You have turned into a hostile witness. So a hostile witness, it can be cross-examined by the person, by the party who actually brought him. Why? Because now that he has turned hostile, we want to do what? We want to breach the credibility of that hostile witness. So a court may, in its discretion, but this is a discretion of the court, permit the person. So you have to take permission from the court, and this permission, it is discretionary. The court may or may not give you that permission. The court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. So now any question which could have been put by the adverse party in cross-examination, the person who actually brought that witness, they can ask the same cross-examination questions to that witness, right? Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such evidence. Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witness. So that evidence by the hostile witness, it can be relied on, right? Question number 9. A dumb person is a competent witness as provided under. So the answer to this question is B, that is section 119 of the Indian Evidence Act. Section 119, witness unable to communicate verbally. So this is evidence by a person who could not speak, who is unable to speak. It can be because he cannot speak due to medical reasons, or he has taken the vow of silence. In any case, if he is unable to speak, in that case, a witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible, as by writing or signs, but such writing must be written and the signs made in open court. Evidence so given shall be deemed to be oral evidence. So the conditions are that the statement, it can be in writing or it can be through signs. They must be made in the open court. If a person, he comes with a written statement, that he has written, he brings that statement to the court, this cannot be regarded here. This cannot be done here because he has to write this before the judge. He has to write this in open court. Evidence so given shall be deemed to be oral evidence. This also you have to remember, that a person, someone who is unable to speak, who cannot communicate verbally, if he is even giving something, he is even writing something, he is giving his statement in writing, then also it is regarded as what? It is regarded as oral evidence, right? So a witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible, as by writing or by signs, but such writing must be written and the signs made in open court. Evidence so given shall be deemed to be oral evidence. Provided that if the witness is unable to communicate verbally, the court shall take the assistance of the interpreter or a special educator in recording the statements, and such statements shall be videographed. In case you are opting for the sign language, you are opting to communicate via signs, in that case, that statement made through signs, that will be what? That will be videographed, right? Moving on, question number 10. A communication made to the spouse during marriage under section 122 of the Indian Evidence Act. The answer is A, remains privileged communication after the dissolution of marriage by divorce or death. So this is the privileged communication between the spouse, between the husband and wife during the course of the marriage. It is, but during the course of the marriage only. During the course of a marriage, if they are communicating, their communication is protected under this section. This is due to the public policy, right? But it is only during the course of the marriage, something which was, the communication was made during the course of marriage, but this privilege, they will be given this privilege even after the death of one spouse or after their divorce, right? But it has to be during the course of their marriage. During the course of their engagement, it is not covered. After their divorce, if they communicate something, it is not covered here. It has to be during the course of their marriage. And in this case, it should be a legally wedded wife or a legally wedded husband. For example, if a husband, he has a second wife and he makes this statement, he makes some statements to that wife, the second wife, that communication between the second wife and the husband, that is not protected here, right? It is the legally wedded wife only. Alright. So no person who is or has been married shall be compelled. They will not be compelled to give statement against their husband. So they will not be compelled to disclose any communication made to him during marriage by any person to whom he is or has been married, nor shall he be permitted. At the same time, they shall not even be permitted. If, for example, the wife, she wants to give that statement against his husband, she wants to disclose that communication, in that case, she is not even permitted. The court cannot compel them. At the same time, if they want to do so, they are not even permitted, right? So no person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person to whom he is or has been married, nor shall he be permitted to disclose any such communication unless the person who made it or his representatives in interest consents, except in the suit between the married persons or proceedings in which one married person is prosecuted for any crime committed against the other. Let's understand this section with the help of an example, right? So there is a husband and a wife. A husband, he returns home after a very long time and he comes very late. He comes at 2 a.m. Home, and the wife, she asks that where you have been. He says that I have murdered C. I have to go. Please just give me some cash so that I can escape. I can flee. Now, in this case, the court, they cannot compel the wife to tell that on that day when the husband returned home, what did he say to you? She cannot be compelled by the court to give that statement. And at the same time, if the wife, she wants to give that statement, if she herself voluntarily wants to give this statement that I want to tell that what he said to me on that day, in that case also she is not permitted. Unless the person who made it consents. Now, when can this happen? For example, now if the husband himself is consenting to this, he actually consents to his wife that you please tell the court that what did I say to you. It can be because now he has turned into an approver, for example. So that is why if he consents to the same, then in that case the wife can be permitted to make that statement. Except in suits between the married persons or proceedings in which one married person is prosecuted for any crime committed against the other. But if the case is between these two persons only, if it is between the wife and the husband, in that case, this privilege as to the communication, this is not given. For example, let's take this example only, that this husband, he returns home very late and the wife asks, where have you been? And now he says that I was with my second wife. I have a second wife also. In this case, now if the wife, she wants to file a suit for bigamy, for example, in that case, or for divorce, in that case, this communication that was made by the husband to the wife, this is not protected and she can be permitted. She can make that statement in the court, right? Except in suits between married persons or proceedings in which one married person is prosecuted for any crime committed against the other. So this is available in civil law also and in criminal law also. So that means this privilege is only available against a third person, right? So I hope now you are clear with question number 10 also. Moving on, question number 11. Under section 118, who among the following are competent witnesses? The answer to this question is E, that all of the above. So every person is a competent witness. You have to remember that competency and reliability, these are two different things. Someone may be a competent witness, but at the same time they might not be a reliable witness. And who is a reliable witness? This is question of fact. So someone can be a competent witness but might not be a relevant witness, right? Let's understand this section also. All persons shall be competent to testify. So as a general rule, everyone is competent to testify, right? So all persons shall be competent to testify unless the court considers that they are prevented from understanding the question put to them or from giving rational answers to those questions by tender age, extreme old age, disease, whether of body or mind, or any other cause of same kind. So the only test here is that they are capable of understanding the question. If they are capable of understanding that question, in that case they are competent witness, and at the same time they are capable of giving a rational answer. They are what? They are competent witness in that case. So everyone is a competent witness. Please remember that everyone is a competent witness, but there is a test that determines that if they are competent or not. So as a general rule, everyone is a competent witness, but if they are unable to understand the very question that is put to them, or if they are unable to give a rational answer, in that case they are what? They are in that case not a competent witness. Explanation: a lunatic is not incompetent to testify unless he is prevented by his lunacy from understanding the question put to him and giving rational answers to them. Right? So this is, we have done, this is section number 118. So that means an accused, an entrusted witness and a bad character witnesses, all are what? All are competent to testify. The accused person was not actually a competent witness until the year 1956. In 1956, a CRPC amendment came. The reason was because the accused person, he could not be given oath until then. But now he is also what? He is also a competent witness. So every person is a competent witness. Question number 12. Presumption under section 113A of Evidence Act can be raised if the suicide by the married women is committed. The answer is within 7 years of marriage. So this is a presumption when the question is whether the commission of suicide by a woman had been abetted by her husband or any relative of her husband. This is by her husband or any relative by husband. The relatives, they can be by blood, they can be by adoption, they can be by marriage. And it is shown, it just has to be shown that she had committed suicide within a period of 7 years from the date of the marriage, and her husband or such relatives of her husband had subjected her to cruelty. The court may presume, having regard to all the other circumstances of the case, that such suicide had been abetted by her husband or by such relative of her husband. So if it is within, if the suicide happens within 7 years of the marriage, in that case it can be presumed that suicide, it was abetted by husband or the relatives if she was subjected to cruelty. For the purpose of this section, cruelty shall have the same meaning as in section 498A of the Indian Evidence Act. Question number 14. The principle that the possession is prima facie proof of ownership is contained in, the answer is B, is contained in section 110 of Indian Evidence Act. So this is burden of proof as to ownership. In Indian Evidence Act, the person who possesses a thing, who is the possessor, he is regarded as what? He is regarded as the owner. And if someone, he wants to rebut this presumption, then in that case the person who wants to rebut this presumption, he has to prove the same, right? So when the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. So here possession actually raises the presumption of ownership, right? So this is possession. Here possession, it raises the presumption of ownership. Who has the possession is considered to be the owner, and if someone wants to rebut this presumption, in that case the person who wants to negate it, he has that burden of proof that he has to prove the same. So when the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. Question number 15. Privilege in respect of husband and wife under section 122 of the Evidence Act relates to, the answer is C, that it relates to both a question which a witness cannot be compelled to answer and a question which a witness cannot be permitted to answer. So it includes both. I have told you that the court, it cannot compel that witness, and at the same time that witness, it cannot be permitted. If she wants to give that statement, she cannot be permitted. So this is question which a witness cannot be compelled to answer and question which a witness cannot be permitted to answer. Now question for achievers. In which of the following cases the evidence given by the witness will not be relevant under section 33 of the Indian Evidence Act 1872? When the witness is staying abroad, when the witness is dead, when the witness cannot be found, when the witness is in coma, or none of the above. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.